The Criminal Procedure Law in the UAE. The Federal Law Number 35 of 1992 concerning the Criminal Procedure Law specifies the procedures for the prosecution of criminal cases in the UAE, Criminal Procedure Code. The rules and procedures concerning investigation, trial procedure, evidence, judgment, appeal procedures, and enforcement measures are stated in the Criminal Procedure Code. What is the public prosecution and its responsibilities? The public prosecution constitutes the judicial authority which is headed by the Attorney General and followed by the hierarchy of Senior Advocate General, Advocates General, Chief Prosecutors, and Prosecutors. The higher members in the hierarchy have the authority to both monitor and supervise their subordinates. As part of its responsibilities, the public prosecution is responsible for initiating and taking action on criminal cases on behalf of the society members, either by referring the criminal case to the court for trial or by issuing a decision of dismissal. Under Article 7 of the Criminal Procedure Code, the public prosecution has exclusive jurisdiction to initiate and prosecute criminal proceedings. It also has the exclusive authority to track the criminal cases until a final judgment is rendered. Collection of evidence. Various government departments are assigned in terms of inspection and collection of evidence, which includes the police department, the public prosecution, and the criminal court. Under Article 30 of the Criminal Procedure Code, the judicial police are tasked with the responsibility to inquire about crimes, search for the perpetrators, and the collection of necessary information and evidence as part of the criminal investigation. Further, the judicial police are answerable to the Public Prosecution Office and are also under the direct supervision of the public prosecutor in the performance of their duties. Case proceedings when sufficient evidence exists. Pursuant to Article 45 of the Criminal Procedure Code, when sufficient evidence exists concerning a given criminal complaint, the judicial police officer may order the arrest of the accused, present and against whom there is enough evidence that he committed a crime in any of the following instances. 1. In matter of felonies. 2. In suspected misdemeanors sanctioned by a penalty other than a fine. 3. In misdemeanors sanctioned by a penalty other than the fine, if the accused is put under surveillance or there is an apprehension of his escape. 4. In misdemeanors of theft, deceit, breach of trust, severe transgression, resistance by force to public authority officers, violation of public morals, misdemeanors concerning arms, ammunition, intoxicants, and dangerous drugs. Other case proceedings. 1. Insufficient evidence. If the prosecution office deems that there is no reason to pursue the action further, due to lack of evidence or for other reasons, it shall order that the complaint be archived and not be lodged with the court for trial. 2. Withdrawal of complaint. The UAE laws allow for withdrawal of the legal action by the complainant in certain types of cases. In the instance wherein the victim dies after submitting a complaint, the right of withdrawal passes to his legal heirs. 3. Lapse of the criminal action. Pursuant to Article 20 of the Criminal Procedure Code, a criminal case shall be deemed to have ceased or lapsed if the following circumstances occur: death of the accused, issuance of a final judgment, submitting a waiver of the case by the party who has the right thereof, general pardon, abrogation of the law which punishes the same act. Further, as per Article 20, a victim shall be barred by limitation period to initiate a criminal action except for quizzes crimes, dia, blood money, and the felonies punished by death sentence or life imprisonment. The criminal action shall extinguish by the lapse of 20 years, and it shall extinguish by the lapse of 5 years in misdemeanors, and 1 year in the case of violations. Such prescriptive period shall start from the date of perpetration of the crime in all cases. Moreover, Article 315 provides that with the exception of quizzes crimes and dia, blood money, and felonies adjudicated by a final judgment of capital punishment or life imprisonment, the penalty imposed in other felonies shall extinguish by the lapse of 30 years. The sanction imposed in misdemeanor shall extinguish by the lapse of 7 years, and by the lapse of 2 years in offenses. The prescriptive period shall start when the judgment becomes final, unless the penalty has been adjudicated in absentia by the criminal court against a felony, as in this case the period shall run as of the day of pronouncing the judgment.
For more of our latest updates, like and subscribe to this channel.